A Supreme Court move just changed 7 gun law rules, and most gun owners still think the old rules still apply. If you follow bad advice from last year, you could walk into a gun store, a traffic stop, or even your own front porch using the wrong rule. Quick question before we continue: are you subscribed? Because what I'm about to reveal could keep you from making a mistake that follows you for years. Hit that button now, because gun laws do not change slowly anymore. They change fast, they change quietly, and sometimes the biggest change is what the Supreme Court refuses to stop. Here's what just happened. Over the last stretch of Supreme Court action, the justices did not just talk about one gun issue. They changed the ground. Under at least 7 major gun law areas, some changes helped gun owners, some helped the government, and some created a weird patchwork where your rights may look very different depending on what state line you cross. First thing you need to know, the court said the government can still disarm some people temporarily. This came out of the Rahimi case. In simple English, the justices said if a person is under a qualifying domestic violence restraining order, and a court has found that person is a real threat, that person can be blocked from having guns while that order is active. Now, why does this matter to you? Because a lot of people heard one message after Bruen. They thought the Supreme Court is about to wipe out all these federal gun bans. That did not happen. In fact, Rahimi told lower courts that some modern gun restrictions can survive if they fit the old American tradition of keeping weapons away from people who pose a danger. Let me break that down for you with a simple example. Imagine a guy says, I still have my Second Amendment rights, so this order means nothing. That is exactly the kind of mistake that can turn into a federal charge. If the order qualifies under the federal rule, the gun rights issue is no longer a debate at the kitchen table. It becomes a criminal case. But here's the crazy part. The second change is not just about restraining orders. It is about how judges now look at gun laws in general. Before Rahimi, many people thought the government had to find an almost identical law from the 1700s to defend a modern gun restriction. Rahimi pulled that back. The court basically said the government does not always need a perfect historical twin. It needs a close enough historical match in principle. That sounds small, but it is huge. Why? Because this changes the argument in case after case. A state no longer has to point to some dusty law with the exact same words. It can say, look, America has a history of disarming dangerous people, so this modern law fits that same idea. That gives governments more room to defend some restrictions than many gun owners expected. Here's what most people get wrong. They hear one pro-gun ruling and think every gun law is about to fall. That is not how this works. The Supreme Court is moving issue by issue. It is saying yes in some places, no in others, and not yet in a whole lot more. Now, this is where it gets interesting. The third change went the other way. In Garland versus Cargill, the court struck down the federal bump stock ban. The justices said the ATF went too far when it tried to call a bump stock a machine gun under the statute. That means the old federal rule that told owners to destroy or surrender bump stocks could not stand. And this shocked a lot of people, because many gun owners assumed that rule was settled forever. It was not. But wait, there's something even more important. This does not mean bump stocks are legal everywhere. And this is where people get burned. Federal law and state law are not the same thing. The Supreme Court killed the federal ATF rule. It did not erase every state ban. So if your state still bans bump stocks, you do not get a free pass just because you watched one video saying, Supreme Court legalized them. Here's a hypothetical example to explain. Say you live near a state border. You hear the federal ban got tossed out. You order a bump stock online. But your own state still bans it. Now you are not arguing with the ATF anymore. You are dealing with state charges. See how fast this gets messy? If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when cops ask about your gun. Subscribe so you don't miss it. These quiet legal shifts are the ones that catch good people off guard. Now let's go to change number 4, because almost nobody's explaining this one correctly. In Bondi v. Vanderstock, the Supreme Court upheld the ATF's ghost gun rule. In plain English, the court said the federal government can treat many gun kits and unfinished frames like firearms if they can be readily turned into working guns. That means a lot of the old talk is now dangerous oversimplification. If the kit is close enough to a working firearm, federal rules can kick in. That means serial numbers, records, licensing rules for sellers, and background check rules can apply. This is the part that shocked me, because so many people still think the law only cares about a fully finished receiver sitting on a table. That is not the real world anymore. The question now is how easily that item can be turned into a firearm. Let me make it personal. Imagine you buy what looks like a harmless kit online because a friend tells you it is not technically a gun. But under the current rule, that item may be regulated like one. That changes how sellers operate, how transfers happen, and law enforcement. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. And here's the part nobody's talking about. The court did not say every unfinished piece of metal or plastic is automatically a firearm. There can still be hard edge cases. But the big takeaway is simple. The broad idea that ghost gun kits sit outside federal law is